All right, we are back on the record after a brief recess to recap where we left off. The complainant had completed its examination, her examination, excuse me, of Ms. Epplett, and Attorney Zacard is ready to conduct her direct examination of Ms. Epplett. Ms. Epplett, you are still under oath. Attorney Zacard, please proceed with your examination of Ms. Epplett.
Okay, thank you. I'm going to start, Ms. Epplett, with clarifying some of the questions that were asked of you on direct. And then I'll have some other questions for you as well. So we had talked a lot about conduct report. Could you please explain kind of what that actual conduct report represents and what it does?
What the conduct report represents?
Well, I'm sorry, let me rephrase that. What is the purpose of the conduct report?
So the conduct report is basically a record of the office, an employee in the institution writing a violation, or what they believe to be a violation of the rules of the 303. So you write a conduct report, and then there's a hearing.
Could you tell us a little bit about the hearing?
The hearing officer goes over the ticket, reads the ticket. If the inmate has gone what we call the long way and not waived as an uncontested, then there can be witnesses that are brought into the hearing for questioning. And then the hearing officer decides basically the outcome, the disposition of the conduct report.
Okay. If they don't waive and there are witnesses, what kinds of people are called as witnesses?
It could be anybody that was involved or the inmate feels has relevant information about the incident or situation.
Does that include, so can both the inmate, well, Attorney Zacard, one thing that it's not entirely clear to me if during these hearings, is there some, and it may not be even relevant, but is there like an advocate on the part of the correctional facility and the inmate, and then they both can present testimony? That's not entirely clear to me.
And I think we would need Ms. Epplett to explain that.
Yep, I'm encouraging you to ask her that question.
Sorry, okay.
I wasn't entirely clear, my apologies.
Okay.
I was just saying that would be helpful information for me to understand context.
Okay, so Ms. Epplett, now you indicate witnesses testify. Does the Department of Corrections typically have the writer of the conduct report testify?
So the writer of the conduct report, if it was if the inmate takes it the long way, it's not uncontested. The inmate is the person who decides ahead of time and submits, if I'm recalling all this process correctly, they submit who they want as a witness there. And when somebody is going what we call the long way, they do have the inmate has an advocate that can help them understand the procedure. The advocate doesn't advocate one way or the other. They simply help the inmate understand the process. And then the inmate ahead of time says who he would like at the hearing, and that may or may not be the person who wrote the conduct report. But I also believe that that list is reviewed as far as witnesses, and I think relevancy of what the witness has to offer is reviewed as well.
So now when you say long wait uncontested, is that what you said?
Correct.
Okay, so if it's contested, could you explain that process?
That's really what I was referring to. is when it's
Okay.
contested. That's where the inmate is assigned an advocate, and they can write out who they want as witness there. And like I said, I believe the relevancy of the witness has to be explained. And I think there's in the process it's determined whether or not it's reasonable to have that particular person called as a witness.
Okay, so if there's a contested hearing and the examiner finds that the ticket's ultimately dismissed, does the Department of Corrections have any way of appealing that, or is it done then?
Um, who would appeal is the inmate.
Okay, so the
There's a
Department of
there's a
Correct,
yeah, there's a formal process for the inmate when it is contested. There's a formal process that they would file in the inmate complaint review system. That's how they start their process for um, basically letting people know that they don't agree with the outcome. But on the flip side, there is no formal, if I understand your question correctly, there's no formal way. Once the hearing is done, it's done. There isn't a way for employees to come back formally and request, a further review.
thank you. And so there were a lot of discussions about different types of investigations. Um, for a conduct report, essentially, is that conduct report the investigation?
In and of itself, yes.
So there isn't any sort of formal process where there's more people assigned and they do interviews. Is that accurate?
Correct. Usually the conduct report is written, the violation is stated in the body of the conduct report. You have the rule that they violated and the context of the violation. I suppose it is plausible that, I mean, really, that's where the conduct report ends at that point. Could an informal investigation or a fact finding spin out of that? I, I, it's plausible, but I can't recall a time that happened.
So the persons who write the conduct report, for example, if it was a sergeant, um, once they write the conduct report, do they have any say what happens with it if it's a major violation?
I would say officers and sergeants don't necessarily have a say, but they can write, like in the conduct report, if I'm recalling correctly. So if it's like a repeat offense, they can note in the body of the conduct report that, maybe this is the third time that they've been warned, or this is the second time they've received a conduct report. And notations like that can prompt the hearing officer to understand, and the hearing officer can see in wicks and warning cards and those kinds of things that if if it's a violation that continues to happen, that will prompt the officer to potentially bump up the discipline.
And in terms of when the conduct report is written, is there a certain type of process that needs to occur in terms of due process rights for the resident or the inmate?
Well, the hearing in and of itself is the due process.
And is the DOC required to give individuals notice of that hearing?
Yes.
If notice is not done properly, is that something that could cause a ticket to be dismissed?
To answer that, I would say, I feel like I've stepped away from the procedure of the due process long enough that there are some, I think there's some processes that I'm not remembering. But it's plausible that if there's a step missed, that it could result in a dismissal.
And I just want to ask, do sergeants have any authority within their job description to um, provide or state what a disposition should be on a conduct report?
Well, I mean, I think, anybody can basically express their opinion as to what they think the outcome should be. Anybody who works in a correctional facility could say, I think they should be placed in a temporary lockup, or I think that they should stay on the unit, or I think this should be the disposition. But that is ultimately up to the hearing officer and the evidence that's in the hearing.
In terms of oh my notes. So could you is there a difference between a deleted report and a dismissed report?
Yes, a deleted report is it's gone. It doesn't exist. A dismissed report it still lives as a conduct report, and the disposition is dismissed. So the dismissed conduct report, there's still a record of it. If I'm recalling correctly, there's still a record.
And if a conduct report is dismissed, um, can that dismissed conduct report stay in the inmate's WICS file?
My understanding is that dismissed conduct report still was an active document.
So, just to clarify, so it's an active document, and if you don't recall, that's okay. Is it something that, when you say active, is it just still in the WICS system somewhere?
Yeah, that's what I meant. Yes, that you can still see it in WICS as a record. That's my recollection.
Would it be in, let's say you looked up a particular resident inmate, would it, if you looked them up in WICS, would that dismissed conduct report be in their record or just in another portion of WICS?
My recollection is that dismissed conduct report is sequentially along with all other conduct reports in that individual's record.
And do you recall what chapter 303 of the administrative code indicates regarding conduct reports that are dismissed?
Not specifically.
If the administrative code indicates that conduct reports are not kept in the inmate file, would that then mean that they're still in their WICS file or just in another place in WICS?
I'm sorry, I'm not, I'm not understanding the question because I'm under the impression from my recollection is that even a dismissed conduct report, you would still find in WICS under the offender's name with all other conduct reports, if that's what you're asking me. Or maybe I'm
But-
wrong. Maybe I'm not recalling correctly.
Okay, so you just not, you think it is, but you're not sure.
I'm not 100% sure, but that's my
Okay.
recollection is that dismissed conduct reports still are at a record in WICS.
So they're a record in WICS, but you're not sure where they're stored. Is that correct?
Well, if I'm making the assumption that the conduct report that is dismissed, my what I would say first is that it's right in where you see all the conduct reports. It should, to me, it should be in there. And the disposition would just be dismissed. I don't know. I'm not aware that a dismissed conduct report lives any other place. But again, I mean, my procedural knowledge I may not be accurately recalling.
Okay. Um, did Do you recall if Ms. Ostrowski complained about any particular issues with um, any residents?
Well, the ones, I mean, the ones that I'm aware of are the conduct reports that we referenced earlier. But I mean, but other outside of the wearing of the ID or not wearing of the ID and the masturbation one, there's the other complaint is what I referenced earlier that I'm aware of is that Sergeant Ostrowski um, brought forward that and with unit manager Lawrence that he had allowed an inmate to like to, he allowed an inmate to essentially violate, I think, his disposition on a conduct report and go to somebody else's door. I could be remembering that, but I know it was a complaint that she would have instructed the inmate not to go to the top tier, and Lawrence allowed that to happen. I'm aware of that. But as far as like other residents, I'm not recalling any other complaints.
Is that the
And
current
if
nomenclature that inmate is referred to as a resident? Ms. Epplett?
yes,
I took resident as inmate.
Okay, thank you. I just want to make sure we're clear on
okay,
that.
sorry
Appreciate it.
about that. And so just to clarify, you had pointed out this particular resident with the, sorry, the masturbation incident. Did Ms. Ostrowski ever bring forth any concerns about that inmate after that report was dismissed?
Yeah, I mean, I believe that was one of the conversations where she had brought forward that, she adamantly disagreed that that was dismissed and that it undermined her as a female sergeant and just undermined the rules in general for enforcement.
And see. In terms of either of these dismissed conduct reports that we described, the one with the ID and the resident who was masturbating, was Ms. Ostrowski disciplined because those were dismissed?
No.
Just my apologies, I want to find something. Do we have the second page of C9?
Do we have the second page of C9? Go ahead.
I'm sorry, I thought
Let me just pull it up and I'll tell you in a second. Whatever was marked as C9 we have, and it appears to me that at this point we just have the first page of C9. Let me pull it up, and then if the parties want to elaborate whether or not I should in fact have the second page. So I've shared C9, which as it's marked is one page. And I think everyone would agree that there's a second page to this. Ms. Keither, do you agree there's a second page to this somewhere?
We believe that that's accurate, and I think it's in the ALJ Brown's exhibit, so I don't know, I could try to pull that up on and forward it. If attorneys.
Well, here's what I'd like you to do at some point, since we don't have the second page, just after the hearing and prior to your submission, your post-hearing submissions, I think we should get the second page in. Attorney Zakard, for your purposes, do you need to ask this witness a question about the second page? And the other thought I have is it's probably in one of the respondents' exhibits too, although I certainly wouldn't be able to tell you which exhibit.
Yeah, I don't think it's in mine. I can skip this one for now.
All right, but just so I think we're missing C3, we established we had the second page. I think currently we're missing the second page of C7 and the second page of C9. I'll follow up with the parties on that when I send you my list of exhibits.
Okay, thank you. Great. Ms. Eplett, we talked a lot about investigations. Are there different types of investigations?
Yes.
What types of investigations are there in terms of that you understand you were asked about?
So there's from my perspective, there's only one formal investigation, and that's when a 15807 is filled out and it's formally investigated, meaning it's assigned to a supervisor. The supervisor investigates, and it's processed through our ER specialist, and it's that we determine, is there even a rule violation? A formal investigation doesn't necessarily mean that it's automatically assumed that there's a rule violation. That's the purpose of the formal investigation, to see if there is. if there, and so the step in there is there a work rule violation? And if so, what is it? And how do we proceed? So meaning because you can offer letters of expectation and it doesn't go to pre-dis, or you can go to pre-dis from there. And then a process happens where it's determined what is going to be the outcome or recommended discipline.
Is pre-dis the first step, or is there a
Pre-dis
step? Go ahead, I'm sorry.
Yep. So the first step is the formal investigation. The investigator should talk to the primary person at some point, but they may also talk to witnesses. They're going to talk to anybody and everybody who may have knowledge or, was part of the event or situation. Once it's determined that there was a work rule violation, the violation is determined, and then after that, the investigator who's assigned goes back to the employee and says, these are the work rules that you were found to be in violation of. Is there anything else that you want to offer as mitigation during the pre-dis hearing?
Okay, thank you. And I just want to clarify, when you say work rule violation, do you mean this is the formal process for employee discipline investigations?
Correct.
Okay, and
but
so-
there's oh,
okay,
I'm
go
sorry,
ahead.
Michelle.
No,
Go
go
ahead.
ahead.
I was
ahead.
just going to say that that's the formal process. There is an informal process. We used to just call it looking into the situation before any investigation was ever determined. Eventually, it came around to a fact finding. But again, a fact finding is just let's get the details of what happened let's get an understanding of what happened to decide if we even need to go to a formal investigation. And then the other thing that I think people also get confused on is when there is an intake done, that's not an investigation. But an intake is a way for the employee to meet with a supervisor to tell their story of the who, what, why, where, when, as to what they thought was harassing or bullying or creating a toxic work environment. That isn't necessarily an investigation, but it can lead to an investigation. When we take that information, as a warden, I would take the information, I would read the intake packet, and then I would make a recommendation to ODES. And more often than not, Tanya, I'm forgetting her last name right now, but the ODES would determine whether or not they agreed with my recommendation or not. And sometimes that recommendation led to a formal investigation.
And what does OATS stand for?
Office of Diversity and Employee Services. I'm pretty sure that's what it stands for.
Okay, so if you refer something to OATS and there's an investigation, is that separate from an employee discipline investigation?
So an intake packet is completely separate from discipline. But again, if an intake is done and there's, reason to believe that we may have a work rule violation of policy of bullying or harassment, that can then lead to a formal investigation. And ODES doesn't have anything to do with that. Once it's a formal investigation, then that goes to our employment relations specialist under the purview of our personnel and DAI.
Now, since we're talking about intakes, you indicated there was an intake done involving Ms. Irwin and Robert Miller. Can you explain exactly what was happening there?
My recollection is, I honestly, I can't remember all the details of what happened, but I know that at some point, I believe Sergeant Ostrowski reached out to Mr. Miller and requested the intake. Because for the intake process, the employees they can do that. They can reach out to any supervisor to have an intake done. And I don't know, I honestly can't remember if I had any involvement in that. I wouldn't have thought that I did, but yeah, I don't remember. But I know he
Oh.
did an intake.
Okay, and I just want to clarify. He was doing an intake because Ms. Ostrowski was a complainant, is that correct?
Correct.
Okay, and Mr. Miller was doing the intake of her complaint.
Right. He was taking down all the information that she shared. And then that gets sent, then I review the intake packet and I send that packet to the Office of Diversity and Employee Services. And from there, it's determined whether or not, what is the outcome? It could be, it doesn't
Okay.
meet the letter of the law of the policy. There's nothing here. Or let's go to formal investigation, or let's do some conflict resolution. Let's do some mediation, those kinds of things.
Okay, because I just wanted to clarify that this wasn't a situation where Ms. Ostrowski was representing somebody or working with Officer Miller as like co-investigators, correct?
No, an intake is when a single employee goes to any supervisor of their choice and they tell that supervisor, and usually the employee goes to that particular supervisor because they trust them. And they tell their story, and the supervisor documents what they're telling them at the moment. Now the person who says, look, I want to do an intake for harassment or bullying or toxic work environment, again, like I said before, they may say, this just hasn't happened to me. You should really talk to these other people. So they could name other people, but usually during an intake, it is about what they have experienced themselves.
Thank you. Let me see here. And just to clarify, typically there aren't any additional investigations done for conduct reports, correct?
No,
Okay. And so and just to clarify, you had indicated that you typically do not get involved with any inmate complaints until after the hearing. Is that right? That's your role?
correct. Correct.
Okay.
If I'm handling anything from the inmate who disagrees with the disposition of a conduct report, it has to have been contested and they have to file through ICRS.
Okay. Do you recall what Robert Miller's role was at that time?
He was the security director for
And
DAI.
okay, and could you tell us what that means then for DAI?
I'm sorry, he was the security chief for DAI.
Is that like the whole adult institutions then?
Correct. So he basically was the security chief for the entire division. And so he did not directly supervise security directors that were working locally at institutions, but he certainly set forth policies and procedures. And, you know, he would, I mean, security chiefs recommend, you know, changes in the institutions from technology to infrastructure kinds of things to policies and procedures and all of our new mail processes, legal work, all of that usually and typically came from directions from the security chief.
Okay, so that was more of a higher level position.
Correct.
Is
Yeah,
that
he
in
was a career executive.
Okay, okay. Was that out of central office then?
That's correct.
Okay. I think you testified that you were at Oshkosh Correctional as the warden for I believe it was about 3 years. Is that right?
Correct.
And how long in total did you work for the Department of Corrections for?
33 years.
Were you working, did you transfer to Oshkosh from another institution when you became warden?
I transferred from Oak Hill Correctional Institution as warden and took a lateral to Oshkosh.
Okay, thank you. And could you tell us about how many individuals in terms of employees that you supervised at Oshkosh Correctional?
So, I mean, ultimately there was, you know, approximately, I think like maybe 450 employees at the time, give or take, due to vacancies. I think 500 would have been the amount if it was fully staffed. But directly supervised, I directly supervised the HSU manager, the deputy warden, the business manager, the two inmate complaint examiners, the warden's secretary, and the business manager. I mentioned that. So those were my direct reports.
Okay. And could you just tell us about your duties as a warden?
Um, Duties of a warden is, I mean, to sum it up, it's basically to follow the Wisconsin statutes, administrative code, to make sure that we have up-to-date policies and procedures that don't supersede the administrative code. Wardens are responsible for, you know, ultimately hiring and discipline and terminations. We're ultimately responsible for training. First and foremost, we are responsible for the protection of the public and then certainly the protection of staff and inmates. Wardens are charged to make sure and afford that inmates have the ability to have the services readily available to them for reintegration into the community. So we're responsible for making sure that we have academics, vocational training, adequate programming that meets the needs of the population. We wardens are ultimately responsible for environmental factors in the institution, the most basic things like faucets running, toilets flushing. Even though there's different departments that handle all of this, it's wardens are umbrellaed for all the departments. Making sure that inmates are getting healthcare in a timely manner, those kinds of things. And when I say these things, these are the kinds of things that I would see like coming through the complaint system for healthcare. But generally speaking, that's what wardens do. And we are, it usually the rule of thumb is wardens are responsible for everything that happens in the community, outside of the institution, and deputy wardens handle the operations within the institution. And when you say that a warden is responsible for, more public things, we're engaging with, it could be judges, the legislator, it could be those external stakeholders that we engage with as wardens.
Thank you for that. That's a lot of responsibility. And just to clarify, so Ms. Ostrowski's position was a sergeant, is that right?
Correct.
Are sergeants considered supervisors?
No, but they're considered lead workers.
And obviously you were at the very, I guess, top of the hierarchy at Oshkosh Correctional. Are you familiar with the chain of command concept?
I am.
And what could you tell us about what the chain of command is?
Chain of command is typically when it's going to your following chain of command is going to the person that is your direct supervisor. If you're talking about inmate chain of command, it's, usually it's going to be the officer, the sergeant, and the sergeant makes the determination whether or not they can have a lieutenant or a captain respond to a situation. So in chain of command, it also encompasses settling things at the lowest local level. For example, with an inmate, even when they file a complaint, they have to state what they have tried to do to remedy a situation outside of the inmate complaint review system, and address it with the first succession supervisor. So that's what chain of command is you go up the rank from whatever your position is, you go up the rank to that immediate supervisor.
Okay. And I probably should have asked you this, but within the chain of command, you're at the top for the institution, but you have individuals who are higher than you in terms of the chain of command for yourself as warden?
That's correct. So for me, my supervisor would have been Stephanie Hovey, the assistant administrator, and going up in the chain of command, then it would have been Sarah Cooper, and then it would have been at the time it would have been the deputy secretary. That changed over enough, but like Jared Hoy, and then ultimately for me, it would have been Secretary Carr.
Okay. So I think if you recall, there was an email that you were sent. It looks like it was sent to people such as Secretary Carr and some others. Was sent back to you to address. Is that kind of an example of where kind of the use of the chain of command, like sending it back down?
Objection, facts not in evidence.
Response, Attorney Zacard?
I know there were she did mention that she had received it from somebody.
Let me just hold on both of you just a second.
I can just ask it another way.
Yeah, why don't you? I mean,
Okay.
I understand the objection, and I just can't recall the specifics. So why don't you? So
Okay.
the objection is sustained. Go ahead and just re-ask it a different way.
Okay. All right. Thank you. So, Ms. Epplett, did you ever get requests from higher ups in the chain of command to address issues that were related to your institution?
Yes, so at various times, staff would email, um, they would, they email Stephanie Hovey, they would email Administrator Cooper, they would email the secretary. And I would say, I don't know how many emails went out of the institution to my bosses, because if they didn't share it with me, they didn't share it with me. I was never the wiser. But I would say probably more often than not, because those folks are removed from the institution and the daily operations, that they would send that back to me and basically say, can you give us some information on this? So that wasn't unusual at all.
Okay, and I guess the same for you if you received information that was kind of not addressed at a lower level, would you then delegate that back down the chain of command?
Certainly, I mean, I could do the same thing. I could send it to, a supervisor and say, tell me what this is all about. Or, I could ask, the deputy warden or the security director, at any given time to say, help me understand this, or do you have any information about this? That's not unusual either.
Okay.
Ms. Eplet, just a clarifying question. It sounds like there's an expectation that the chain of command would be followed with respect to issues or concerns, but is it fair to say that in your experience, it often was not followed?
Um, I'm not sure that I can use often, but and let me just say too that it also, um, whoever our secretary was, they would really kind of set the pace for how open their door was for employees reaching out to them. Some secretaries engaged directly with the employees, some secretaries bounced it back to, the wardens. Um, so so I would say, I don't know if that I would say often, but I would say it wasn't unusual either.
Thank you.
And in terms of um, the conduct reports that were mentioned earlier, the one with the ID and the one with the individual masturbating, did you have any concerns about how either of those were processed, if you recall?
Um, I, I would say, whatever I questioned, if I questioned anything, I must have been satisfied at the time that it may have made sense.
Um, are you aware of anybody trying to dismiss any conduct reports written by Ms. Ostrowski to um, discriminate against her?
No.
And in terms of uh, the investigation that was done of Ms. Ostrowski's book rule violations, do you recall what the concerns were in terms of book rule violations?
Objection.
What's the basis of your objection?
Are we talking about work rule violations now?
Well, I think your
We were-
objection
we
is
were barred from that.
well, I think the objection is that it's vague because I don't know what a peripheral investigation is or violation is referring to. So perhaps you could be more specific.
Well,
I'm
and
not making a,
additionally-
I'm not making a ruling on Ms. Keither's objection because I don't know what peripheral means. So let's hear what you're really getting
Well-
at, and then.
One more, I thought we all agreed earlier that there was no investigation. So what
Well, that's
investigation?
not an objection. You can address that and redirect if you want. I don't know what her question means, and so we need to understand what her question means. What are you referring to with peripheral investigations?
Oh, I didn't say peripheral. Let me just
Oh.
reword the question.
Okay.
Okay. Are you aware of any work rule violations that Ms. Ostrowski was investigated for during 2022 or 2023?
Yes,
And Ms. Ostrowski was, do you recall what the last discipline investigation was for?
the last one would have been the unauthorized use of inmate information.
And did you initiate that investigation?
No, I did not.
Or you asked to be a witness for that investigation, if you recall?
I think I was in that one, but I believe I was interviewed for that. Yes.
And are you aware of anyone trying to discriminate against Ms. Ostrowski by initiating that investigation or conducting it?
No.
Did you ever try to discriminate against Ms. Ostrowski for any complaints she made during 2022 or 23?
No.
And I take it you're also familiar with all of the executive directives related to the Department of Corrections?
Yes, I'm familiar with them. Not as familiar now as I was then, but
So I think earlier you had indicated that you reviewed a number of executive directives. Perhaps at this point, we could pull up Respondents Exhibit 1.
Just so everyone is aware, Respondents Exhibit 1 has already been received into the record. Go ahead, I have Respondents Exhibit 1 up. I can't recall, it's 10 pages, so you're going to have to direct me or the witness
Okay.
to where you want her to look.
Okay, I guess without going through all 10 pages, Ms. Eplett, do you recognize this document?
I do.
And what is this document?
Executive Directive 2 for employee discipline.
As part of your duties as warden, is this something that you would utilize in the course of your duties as warden?
Yes.
And what exactly does executive directive, how would you utilize this in the course of your duties as warden?
As a guidance document regarding the steps of employee discipline.
And does this document also if I could direct your attention to page 7 of 10.
All right, I will be there momentarily. Let me
Okay.
just minimize it a little bit. Ms. Eplet, it's kind of small there. I guess I'm going to enlarge it, and then if you need me to scroll down, just let me know. But just as everyone can see where the cursor is, we are on page 710. Where would you like?
If she could look at G, letter G.
Okay. All right. We are on G. Can you see that okay, Ms. Eplet?
I can, thank you.
Okay. Yep. Go ahead, Attorney Zaccardi.
Okay, thank you. Do you recognize what letter G is on page 7?
Serious acts of misconduct.
And could you just tell us what serious acts of misconduct means?
It means that if there's a violation of one of those work rule violations, it can have a greater impact on the discipline that can be imposed.
And if you recall, do you recall if there was a serious act of misconduct that Ms. Ostrowski was investigated for? If you recall, if you don't.
Yes, I believe that was the last one, and that was for the use or misuse of inmate information.
And in terms of Executive Directive 2, you indicated this as a guideline in terms of employee discipline. Is there any other policies that sometimes you would have to refer to in terms of the discipline process? And I can reword that if it helps.
Yeah, as far as the discipline process, I mean, there's the work rule, there's work rules, and there's it defines what, outside of those two policies, I can't recall that there's any other policies that guide that.
Okay. And I'm just double checking my notes. Oops. I'm sorry, I'm trying to find something here. Actually, I don't have any further questions at this time.
All right, so the Attorney Zaccardi has completed her direct examination of Ms. Eplet. Ms. Keither, do you have any, I guess we would call them cross-examination questions that would be limited to the subject matter of what Attorney Zaccardi asked, because you have already had your chance at the more expansive, which we will call director adverse. Do you have any further questions for Ms. Eplet?
Yes.
Okay, any sense of, is it going to be, are they minimal, or do you think it's going to be longer than 15 minutes?
It's not gonna be probably under 15 minutes, but I am trying to organize exactly what was brought up in redirect, so, or
Well,
cross, I
let's do
mean,
this. Let's take just a very short break till 12:50. Perhaps that will give you a little time to organize to be more efficient. So let's just all come back at 12:50.
okay.
Okay, thank you. ALJ Reinhardt, I'm sorry, for some reason my camera's not working.
Who just said
Oh,
that?
It's Michelle Zacard. My camera
Oh,
isn't
attorney.
working.
Well, if you're not asking questions, I don't have an issue with that.
Okay.
Do you think you're going to be able to get your camera working shortly?
It says try turning it off and on again. I can, or I have to use another device.
Well, why don't we do this? Why don't let's go through the cross-examination of Ms. Eplet and we'll see where you're at that time. So I don't
Okay.
have any issue. So go ahead, Ms. Keither, with what we will call your cross-examination of Ms. Eplet. Just again, reminding you that's not an opportunity for new areas. It's really cross-examination that relates to the questions asked by Attorney Zacard. Go ahead. Oh, you're on mute. Ms. Keither, you're on mute. Go ahead.
We're gonna start with C11, please.
C11 should be up momentarily. All right, C11 appears to be, at least according to the label on the document, one 3-page document. Let's just check. That's what it is. Go ahead, Ms. Keither.
ALJ Reinhardt, this I think was a page 3, I believe is a different document.
Okay, well, let's just clarify that. I don't know well, let's ask the respondents team. The way I understand it is it may be different documents, but the exhibit C11 is 3 pages.
Yeah.
Ms. Keither, is one of these pages not, are they different documents? I understand it's one exhibit, but the question is whether or not it's one document. It appears to me that just looking at it, that Attorney Zacard is correct, that the actual summary of investigation findings is 2 pages, and then the 3rd page is actually from another document. Can you clarify, please, Ms. Keither? I just don't know.
These were follow-up emails, like on page 3, but we are not gonna ask any questions about page 3. It
Okay,
does
that's
all
fine.
kind of, yeah. Okay, so we're gonna focus on really just the first page.
And just one other thing, because I am going to ask you at some point if you want to offer it. My guess is if you're not going to refer to page 3, then probably when you offer it, you should offer the first 2 pages of Exhibit C11. Just point of clarification. So go ahead.
Okay.
So Ms. Eplet, just so you understand, we're really focusing on the first 2 pages, which appears to me to be the summary of investigation findings from incident date July, August, and September of 22. Go ahead with your question, Ms. Keither.
Okay, thank you. Ms. Eplet, do you recognize this document that's called the Employee Investigation Report Summary of Investigation Findings?
Yes,
Okay, so these are generated when an investigation has been conducted, and these are what are reported as the summary of those findings, correct?
correct.
Okay, and you'll notice this is for Ms. Ostrowski, this investigative finding, correct?
Correct.
You'll also notice dates of incident dates that are listed there. So I'm not going to go over those right now, but I want to draw your attention to them.
And before you do that, I just want, so I have context, is this document, where does it fall in the process? Is this part of the pre-disciplinary investigation, or is it a different stage? If you know. I'm just trying to fit it into what you described earlier about the discipline process, Ms. Eplet. Do you know where in that process this document is generated?
So summary of investigation findings would be the summary of the investigation. It would be part of the investigation, but before pre-dis.
Okay, thank you. Go ahead.
Okay, so if you could go down to 1, 2, 3, the 3rd paragraph. that starts with IO investigators conducted a witness interview with
Mhm.
Warden Cheryl Epplett. So you were part of an investigation. You participated in an interview, correct?
Correct.
Do you remember who interviewed you?
I can't remember the names of the investigators for this. It
Okay.
would be on the paperwork somewhere, but offhand I can't remember.
And IAO is, what does IAO stand for?
Internal Affairs Office.
Okay, thank you. Now, about midway in the paragraph, there is a sentence that begins with, well, I hate doing this because it's hard. It's like 5 or 6 lines down.
What does it start with?
She indicated, see, the sentence starts in the middle, so,
Gotcha.
maybe,
Oh,
yeah,
I
if
can
you,
put my cursor there. I think it's right after false. Is that correct? That's where you want?
yes,
Okay.
yeah.
So do you see where my cursor is? I know it might be hard to see, but where Ms. Keither wants to focus you is right after false, where it starts. She indicated the best of her knowledge. So are you there?
Yep, I
Okay,
am.
go ahead.
Okay. And in this interview, you suggested that Officer, I always say the name wrong, Bringy, I say Bringe, Bringy, Officer Bringy, was not present when an assault on a person in your care, the resident, was when it occurred. I'll re-say that because that was horrible. In this interview, you state to the IAO investigator that while an inmate was assaulted, that Officer Bringy was not present. Is that correct?
If that's what I said, that's correct.
Okay. Now we'll go to C10, please.
Right?
Oh,
Are we
wait,
going
you know what? Before you flip, just for sake of efficiency, I am going to have you look at one more piece, which is the paragraph directly above that starts with, it's towards the bottom third of the paragraph that begins with IO investigators conducted a subject matter expert review. And I'm going to take you down, like I said, to the bottom third where PCO Eggert is listed.
And so where my cursor is, where you see that, is that the first reference? That's where you want her to be, where it says
Yes,
PCO Eggert
perfect.
said F. Okay. You see that, Ms. Epplett? You see where
I
my
do.
cursor is? Okay, thank you.
Yep.
Go ahead, Ms. Keither.
Okay, and when you read this, Eggert said if PHI is shared without written consent, and there is not a legal exception present as defined by HIPAA, DOC would be at risk of federal investigation, and it goes on. Do you know if Mrs. Ostrowski violated PHI? Was there PHI breach?
That's my understanding of the essence of the investigation. That's the essence of it, is that there was PHI information that was used beyond the business need.
Okay, so that's your understanding. Thank you. Now we can move on from there and go up to C10.
Before we do that, did you want to offer the first and
Oh, the
second
first 2
page of
pages.
C11?
Yes.
Any objection, Attorney Zacard?
My only objection would be that this is a hearsay document and it can't be used to prove the matter directly.
So let's just discuss that. So that's really, I think, more of a comment about what the state of the law is, that I can't make dispositive findings of fact based on a hearsay document or hearsay information. However, I would just state that there are certain, whether or not is in fact hearsay or subject to some exception, that's a different issue. Whether or not this, so I'll just say that we're not going to make any determination. So I will receive the first 2 pages of Exhibit C11, not the third page. Then we're going to C10. So let me just make my note here, page 1, 2, then we're going to C10. Okay, and C10, let me just see if C10's in yet. It does not appear to be in yet, so go ahead with your question, Ms. Keither.
Okay, Ms. Eplet, is this an email from you to Amy Romanesco and Genevieve Calderon?
Yes,
Okay, and what are you alerting them to? Well, first of all, who are those two people?
they were probably the investigators.
The internal affairs investigators?
Correct.
Okay, and what did you have to email them and let them know?
So I don't know necessarily what prompted me to do follow-up. Somebody must have prompted something and I followed up, and maybe I looked into something where I say I stand corrected. And Lieutenant Botts was the one who had dealt with the situation, engaged with the situation. And it sounds as though that I may not have, I think initially I may not have known about any of it. And then it was brought to my attention. And that's when I may have looked into it, or, what happened kind of thing. And I
this
was
was
following.
I'm sorry, I didn't mean to do that. I thought you were pausing.
No, you're good.
So was this after the internal affairs interview that we just looked at in the investigatory findings?
I don't remember what the date was on the investigatory interview I had.
Well, let's just look so we don't waste time on this.
Mhm.
If there is in fact a date, can somebody tell me where the date might be?
It's not gonna be on that document.
Okay.
Right, that's.
All right,
we
so
were
I'm
gonna
sorry,
do-
I stand corrected. So the question is legit. Go ahead, Ms. Keither.
Pardon me though, but I can say, and that's one of the reasons why we highlighted that introductory statement, is that on December 7th, they interviewed her. So that first paragraph gives us, gives us a point in time that we read. IAO investigators conducted a witness interview with Cheryl Eplet on December 7th, 2022. So if we look at the date of this email, it's the same day.
Would you agree, Ms. Eplet? It appears
Yep,
to be.
Yep,
Okay.
and it looks as though I followed up with something.
Okay, thank you.
And so that something was actually that Officer Bringy was present during an assault on a person in your care.
I'm gonna object as to relevance.
And let me tell you, I will. I don't know if it's relevant or not, and here's why. There is a reference to this particular incident in the investigatory findings, which led to the predis, which is an issue we're here to discuss. And so I'm going to overrule the objection. I suspect, Attorney Zacard, you may object to this exhibit. And if you do, I will just tell you I'm going to reserve my ruling and the parties can argue it, because I just am not prepared to understand how this relates. Again, it is part of the investigatory interview that led to the pre-disciplinary meeting that is at issue in this case. So I just want to give everyone a background. So the objection is overruled. Did you want to offer Exhibit C10?
Yes.
And Attorney Zacard, do you have the objection that I anticipated you're having, or are you okay with the receipt of Exhibit C10?
I'm going to object that there's not a foundation sufficient.
Well, let's talk about that, because the foundation is, this is an email from this witness. So how do we not have the foundation for C10?
To the
guess,
internal
can
affairs
I-
investigators.
Attorney
I
Zacard?
mean, if it's being used to prove the truth of the matter asserted, I don't think anything other than the first sentence was testified to. or that she remembered exactly what this was.
Well, I'm going to overrule the objection on foundation. Do you have any other objections to the exhibit?
No.
Then C10 is received. The parties
you.
can argue the weight of it. And again, as I said, I just don't know how it fits in. Any other questions for this witness, Ms. Keither?
Oh, yeah. We need to, this exhibit is completed, but interestingly enough, we're gonna go to exhibits 60 through 65. And the reason why, I'm giving that clump is because, we have single pages due to the way we have to fax things at a public facility, that this is one document that's kind of, each page is labeled as a different exhibit.
I understand. So what you're
It-
saying is 61 through 65. If you put them together, it's actually one document, but it's been marked this way. I have 61 up. Go ahead.
We
I'm
actually
gonna
gonna start
object
with
to the re-
60.
All right,
I-
hold on a second. I don't want people talking over each other. Attorney Zacard, I don't know, there hasn't been a question asked yet, so I don't know
Okay.
what your objection is. If you have an
Okay.
objection, let's wait to see what is
Okay.
asked. I can't rule on an objection when I've just pulled up an exhibit. So, Ms. Keither, go ahead and ask your first question with respect to exhibit C61.
Actually, we're gonna start at C60, so we'll just go back one page.
Oh, I'm sorry. I think you did say
Okay.
that. C60. Okay. All right. We
Okay.
have C60 up, and does this relate to the particular investigatory report? So this is the same incident, correct?
These are the same things that Attorney Zacard got into on her examination.
All right. So go ahead and ask your
It-
question.
Okay, so who is this document written by? If you can see that on the form.
Yeah, this would have been filled out by me.
Okay, so you're the author of this report.
Correct.
And what is the what is this type of report about? What is the title of it?
Privacy breach incident without PHI, report by supervisor.
So this says without PHI. Is there another report another breach report that can be filled out that is an incident with PHI?
I'm assuming so, but I can't say absolutely like for sure this is the form, but it would make sense.
Did you ever fill one out before, besides Miss Ostrowski's?
I think I have filled out privacy breaches maybe twice in my entire career.
Okay, and in the document, we're gonna scroll down to the kind of towards the bottom.
Of the first page or of the
Yes, the
document?
first page of the
right.
first page. Thank you.
All right.
So I see that the date there says under description of incident, it says the incident happened around October 13th, 2023. Is that correct?
I'm assuming so.
You know when Miss Ostrowski's employment ended with the Department of Corrections?
I think it was April 23rd or 24th of 2023.
So this report was written many months after her termination.
That is correct.
Is there a reason why it was written so many months after her termination?
I honestly, I think what happened was because I wasn't the one who prompted the investigation. And so as far as filling out the paperwork for the breach, honestly, it slipped off of, I think, everybody's radar. And at the end of the day, I don't know if it was, I think it was Stephanie Hovey who looped back to me and asked if I would fill this out. And I filled out the form. But it was, as I had testified before, this was what I believe and what I recollect as it was simply an oversight. And I think because there were enough people involved that I don't know if somebody just assumed somebody else would be doing it. But at the end of the day, it was not completed
Okay,
until this date.
can you describe why this is a without PHI violation, but in her discipline, it says with PHI? Why is there a discrepancy?
Yeah, and I can't explain that. I don't know if I used the wrong form, although nobody ever came back and said, "Hey, you've used the wrong form. You need to fill this form out." That did not happen. And so I don't know if if the protected health information at the end of the day was personally identifying information, but if through this investigation, I was certainly under the impression that it was protected health information.
And it was such a serious breach that you thought a skip determination was applicable.
Objection relevance.
Sustained.
Okay, so at the bottom of this document, it's kind of, you might have to just go back a little bit, ALJ Reinhardt. Oh, back to C60, yeah. Right, okay, but come to the bottom of the document. Again, just to ask, did you, earlier in your testimony, you said you often spoke to people that were involved. Did you ever speak to Miss Ostrowski about any of this?
Objection relevance.
So let me tell you what I'm thinking, and then we will get Ms. Keither's position. I think it is relevant because there was a time period at issue from when the alleged violation occurred until the pre-disciplinary investigation, when I think it arguably might be relevant as to whether or not Ms. Epplett talked to anybody. So for that reason, I am going to overrule the objection. I want just everyone to be cautious. I don't want to get into termination issues, but I think it's a legitimate
Well,
question.
she spent a big deal of time on it in her examination.
She didn't spend a big deal of time talking about termination. So I ruled in your favor. Is there something else you wanted to say, Ms. Keither?
No, I'll just wait for her answer.
Do you recall the question?
Um,
I was asking the witness, not you. Let me.
oh, I'm not,
Can you repeat it?
Yeah, let me get back to the question. Hold on a second.
oh, it was, did you ever talk to Miss Ostrowski about this?
I don't believe that I did.
Okay. And so do you think anybody talked to her about what was in these documents?
Objection relevance.
Well, I don't. My concern is she doesn't have the foundation. You're asking her to speculate. Can you rephrase the question?
Sure, we'll just move on.
All right.
Do you see the area that is redacted?
I do.
It is come to our attention that you are the only person who knows what's under those redactions. What is under the redacted portion of this?
I thought that was the inmates that had the information released. I thought those were the names of the inmates where the PHI was taken and sent to Eric Ferguson.
Okay, that is somewhat helpful, but are you sure that that's what's under there?
I can't say 100%, but I don't know what else would be. I don't know what else that would be.
But did you type it?
I'm sorry, Michelle.
I'm sorry, it just relevance. Typing.
So are you interposing an objection because it sounded like you were going to and you didn't? So I need to know for the record if you're objecting.
Objection relevance.
And
she's already asked and answered it. She's not sure.
Well, let me just ask, Ms. Keither, what is the relevance of that information?
Well, it's again, something, Ms. Ostrowski has never been informed since all the paperwork was completed after her termination. She, to this day, does not understand what the issues are for her discipline. And these breaches are right in line, and all the dates are right in the line with dates that Ms. Ostrowski made complaints. Matter of fact, they're the same dates. And so we have been playing at a disadvantage this whole time, not knowing what other people are writing and seeing, and it's very challenging. If she knows what it is, that's lovely. That'll help us. If she doesn't, we can move on. Nobody knows what that says, so we've asked every witness that has their hand on this, and nobody can tell us what's under there. So
Well, let's just ask the question and move on, because I don't think this is particularly helpful to me. Ms. Epplett, do you know what you typed in the portions of this document that are redacted?
I believe that those are the names of the inmates that were on the, that were the names of the inmates and their information that was sent to Eric Ferguson. That's the
All right.
only thing I can think of that would be.
All right,
Okay,
Ms. Keither,
and
next
so-
question.
all right, then we'll go to C63. And I'd like to draw your attention. Again, this is an investigatory tracking document that is part of this investigation. I'd like you to look at the very bottom where it says the breach start date.
Objection, lack of foundation.
Well, she hasn't asked a question yet. She's asking the witness to look at something.
Okay.
I would just generally say that if this witness has never seen this document and isn't able to comment on it, then there is a lack of, there could very well be a lack of foundation. But why don't you ask the question and we'll see if there is. And Ms. Keither, go
Okay.
ahead and finish your question, please.
Do you see a number? Let's go to the top of the document. Do you see a number next to breach tracking number?
Objection, form of the question.
Overruled. Are you asking
Um,
her, does she see GWA?
Yeah, do you-
Do you see that, ma'am? Do you see
I do.
that number? Okay, what's your
Yes.
question?
Do breach reports get a tracking number?
I honestly have no idea.
Okay. Do you know if there's a reporting system for potential breaches?
The only reporting system that I know is these forms.
Thank you.
That's
So let's
the
go
only
down to
thing
the
I'm
bottom.
familiar with.
Okay, thank you. So I'd like you to look at the breach start date and also the discovery start date. Why would the discovery start date be several months after the employee was terminated?
That I can't answer. I don't know why that information is reflected the way that it is. I can't begin to guess.
So, but you will agree that if she was terminated in April 2023 and the discovery date didn't even start until October, that is quite some time later, correct?
I'm gonna object, lack of foundation with this witness.
Well, it's argumentative. The dates are what they are, so the objection is sustained. You're not getting
Okay.
anything new. You can argue the dates. So anything else on these documents?
Is there anything significant about the dates that we were just looking at the bottom of that form? For example,
Objection.
8/8/2022, do you know what date that is? And
I
why
do
it's
not.
significant?
I do not.
Okay. Could it be the death of the inmate was on that date?
Objection, relevance.
Sustained. The witness said she didn't know. So the objection is sustained.
Okay, we're gonna go to C75.
All right, before we do that, what, if anything, do you want to do with C60 through C60? Hold on a second.
We'd like to admit them.
So, well, when you say them, are you talking about C60 through C65?
Correct.
So the complainant has offered C60 through C65 attorneys a card. Any objection to the entire exhibit or any portions thereof? And when I say the exhibit,
Yeah.
the way I state it that way, it's multiple exhibits with one document. So if any objection?
Just to clarify, you said C60 through C65?
Yes, that
Correct.
Yep, that's correct.
And I'm sorry, I just have to look at
No, that's okay. I
all the
understand. It's a
pages
little,
here.
yep. Why don't we go through each page? Perhaps that's any objection
Okay.
to C60.
Oops, I'm sorry. I was trying to look at a different copy of it. So I have no objection to this particular document.
C60 is received. Now, I believe C61 is part of that document. So do you have any objection to C61?
I do not.
C61 is received. Then C62 seems to be just the last page of the document. Any objection to C62?
No.
All right, then I think we get into perhaps, it's not, I got to tell you, it's not clear to me if C63, C64, and C65 are part of the prior C60 through C62. It appears to me that they are a different document. Would you agree,
Yeah.
Ms. Keither, or am I just reading them incorrectly?
Well, it depends on how I mean, they're all generated from the same system. So,
All right, well, regardless, we don't need to get into how
Right,
the parties characterize it. So
Yeah.
the question is, do you have any objection to C63, 4, and 5, which appear to at least go together, attorneys a card?
So my objection would be to the weight these can be given because I don't think anyone has testified they created these documents.
Well, but so you're objecting to
Yes.
foundation as
Yes.
opposed to weight. And I don't, have
Yes.
we had any testimony by anyone who has said what these documents are or where they're from?
Well, I believe we just did that when they're assigned a tracking number in the system.
Yeah, but this
It-
witness says she wasn't familiar and the
Yes.
witness hasn't tested. No, she said she wasn't familiar with this document. She said she's generally familiar. There are some documents. Well, let's just ask her. Ms. Eplett, have you ever seen C63?
Yeah, I mean, I have not, and if I have, I don't recall, but I think what happens, and I'm guessing, is I fill out a portion of a form and I submit it electronically, and then I'm forgetting her name. That was Linda Eggert, that she completes the rest of it, or something is auto-generated. But like
Right.
this information, like I didn't generate that information. I fill out the form, and then it goes to the privacy officer, and they do what they do with it.
Right. So that's what I was trying to say in the beginning is this is like a template that lives inside of a program that is accessed and used for the purposes. And if you look on the first page, it even says, thank you for filing a breach notification via the website where she just described.
It says
I heard her say
offices.
she recognized it.
Go ahead,
Again,
Attorney Zacard. I don't want to
thank
hear
you.
Let's not have people talk over each other.
I'm so
Go ahead.
sorry.
No, go ahead. Go ahead.
There's no, okay, so it says filing a breach notification via the website of the Office of Civil Rights, the Department of Health and Human Services. This is not, I don't think this is a DOC document.
Well, you
Well,
can't testify to that.
Well,
Well,
yeah,
no.
but you have the
But
obligation to establish that it is what you're saying it is. And I haven't heard this witness say,
Yes,
I can say that I gave information and then that information was downloaded into this template. I haven't heard her say that.
She just said it. She said she inputted this information into a
She-
system, and then Linda
No,
Egger.
no, she
took
didn't.
it-
She said the process I follow is I input. She didn't say, and I'll ask her again so the record's abundantly clear. Ms.
What does
Eplet,
input mean?
Ms. Eplet, can you tell us that you inputted information to some computer that resulted in C63, C64, or C65?
I have no idea. All I know is that I fill out the initial part of the form that was shown to me before, where the names were blacked out. That's the part that I fill out and I push submit.
Here's what I'm going to do. I don't want to waste further time on this. I will reserve my ruling. Both parties can address it in their briefs. I do not believe foundation has been established that this is a document.
Well, I heard her say she recognized these forms. That's why we were able to continue.
Well,
with
that's
the
not enough.
questioning.
I can look at 100 forms and say, yeah, I recognize I've used that form in the past. That's different than saying this is a form that was prepared based on information that I provided. That's a different thing. So I'm reserving my ruling. The parties can argue about C63 through C65 in their briefs. Where do you want any further questions?
No, we're gonna go to C51 next.
Just a comment. I thought I heard you say you had about 15 minutes of cross-examination. How much more do you have for this witness?
10.
Where do you want to go now? Did you say C50?
C51. Rounding.
All right, we're on C51. Go ahead.
Okay. All right, and do you see this email from Tracy Fink? And you are copied on this email?
I do. Yep.
And the date is September 12th, 2022. What, as the, and you were the appointing authority, so you were copied on this email, but what does it say about mitigation?
Objection, I think this is cumulative.
Well, I don't know that's cumulative, but we're not going to have the witness read. If you want to get the document in and you can argue it in the brief, we don't have to, asking the witness what it says is not helpful. I can read.
Well,
if you have a follow-up question, that's fine, but I don't need the witness to read what is stated in the document. Go ahead.
Okay, did you say earlier in your testimony that mitigation is part of the due process or investigatory part when there is an investigation into an employee? I wrote down that you use that word. You consider mitigation. Did you say that earlier?
I did. And during the pre-dis is when employees can say what, their mitigation is during the pre-dis hearing.
Okay, and so as the appointing authority, you were told to disregard mitigation in the pre-disc.
Objection.
Well, did you do that?
Hold on a second. So just hold on. I understand your objection. What I think Ms. Keither is trying to get at is, did you interpret this email from Ms. Fink to tell you to skip mitigation? Is that the question you have? Or is it different than that, Ms. Keither?
I would say this document itself is outside the scope of what direct was.
Well, and here's what I'll say. You did ask her questions about the process, and she did testify about mitigation in response to the questions. So I don't think it's outside the scope of this cross. So back to you, Ms. Keither. Is that the question you're asking her, whether or not she took this email to be a direction to her to skip mitigation? Is that your question, or is it some other question?
Yes, it's my question.
Can you answer that question, Ms. Eplet, please?
I think when Tracy said, please go directly to pre-dis regardless of any mitigation provided, when it's my recollection is when we were doing in attendance violations, that's what this is, right? Attendance, that in an attendance investigation, you do the investigation and you go right into pre-dis. Normally in an investigation, you do the investigation, that comes back to the executive team. We review that and determine if we're going to go to pre-dis. But when it is, and again, pre-dis is where the employee gives mitigation. When it came to attendance, we would do the investigation and the supervisor would go right to the pre-dis. It's not that you're skipping it, you're going right into it without a break in it or just and review. And the employee still can, they can still provide mitigation. It's just that you're doing the investigatory and you're doing the pre-dis all in one meeting.
Is everything you just stated written down in policy?
I believe it's in, yes. I can't say for sure, but that was, if it's not like in the executive directive or the work rules, but I believe it should be in the work rules, and otherwise it's an HR policy, and that's how we were directed, is for attendance, because attendance, I think the reason that they went this way is because attendance is usually pretty much cut and dried. And so as not to prolong the process, they directed us that you do the investigation, the investigatory, you go right to pre-dis in the same meeting. The employee certainly has the right to tell their mitigation, but it's done in one meeting.
Okay, and so you're saying that this is a written work rule?
I believe it should be written, it certainly should be written somewhere.
But
You want
do
to
you know
offer
where?
Okay.
Okay, you don't know where. Yes, we need to offer exhibit 51 and we're gonna, yes, go ahead.
Any objection to exhibit C51 being received into evidence? Attorney's a card.
No.
Exhibit C51 is received.
Okay, and can we look at C53, please?
Okay, we are on C53.
Just one page, I think, yeah.
Okay, go ahead.
Okay, so do you recognize this document?
Yep, the pre-disciplinary meeting. This was. Okay,
You do
So,
recognize it, Ms. Epplett? You've seen it before?
I do.
Okay,
Yes.
thank you. Go ahead.
so in this document, this is the document where the mitigation was, because it was an attendance issue, the mitigation was not considered, correct?
No, the mitigation was considered.
Okay, I thought you, okay, just said that it's written in attendance is cut and dry, so mitigation isn't.
No, what I meant was attendance violations were the only work rule violations that we would do the investigatory and the pre-dis all in one meeting. So the employee can still give mitigation, just like in any pre-dis. It's just that with attendance, we did the investigatory and the pre-dis all in the same meeting.
So
But
why
mitigation was still considered.
would Tracy Fink email you and tell you to disregard it then?
Objection. She can't answer that.
Sustained.
Can you read where it says employee response? Just take a moment and read that, please, and then let us know when you're finished.
Okay.
Okay, does, Ms. Ostrowski suggest that doctor's appointments are part of her attendance issues?
I'm gonna object. It's
Sustained.
basically,
The objection is sustained. You're asking for her interpretation. The document says what it says.
Okay, so how did you consider this information when you made your skip to termination determination?
objection relevance.
Well, I don't think it's, no, that objection is overruled. I mean, the first question is whether or not she considered the information, and then if she did, how she considered it. So let's ask the first. Ms. Epplett, go ahead, Attorney Zaccardi. I want to give you a chance to make your record. Go ahead.
I'm sorry. I'm looking at the dates of this, incident dates, interview dates. I don't think there's been a foundation that this is related to the termination for one.
Well,
think
we're not talking about the termination. We're talking
Yes.
about so the claim is that there was discrimination against the complainant because the complainant made a complaint under the Wisconsin Fair Employment Act. My understanding of what the discrimination is claimed is that she was forced to go to a pre-disciplinary meeting after she made the complaint. And so how is that not relevant? Maybe I'm missing something.
I guess because this isn't the same event. This is a different investigation.
Well, it's the only investigation
It's
that exists. And
it
it's all about mitigating factors and
this-
disciplinary that this appointing authority used
Uh,
in her treatment of the employee, Mrs. Ostrowski.
this
Is there official
This is-
paperwork? You talked all about investigations.
Well, here's
This-
where I am confused, and I will let Attorney Zaccardi, I want to hear
Okay.
from you on this. When I'm looking at the initial determination, and specifically subparagraph L, what's discussed in the initial determination is discipline relating to accessing records without apparent business need, sending them to her personal email address, disclosing health information of inmates, and making false accusations about other workers. And so I guess really I will direct this to you, Ms. Keither. Are you aware anywhere, because it sounds to me, and maybe I'm wrong, that there were 2 investigations of Ms. Ostrowski around this time, one relating to the personal identification information, which is what she provided to the Equal Rights Division, and then something relating to attendance. Am I incorrect about that, Ms. Keither?
Partially. There was an investigation for the violation of what flip-flops back and forth of PHI or non-PHI because birth date. Can I finish? And then there was a skip to termination that went into effect. And remember, that's the problem with getting paperwork 10 months after you've already been terminated. You don't even know what they're talking about. And actually, her termination letter says that she shared pornographic material. And that was the serious offense for which she was terminated. You wouldn't let us get any of that in. However, that's what we found out months later.
Right, but you've brought all that up in the termination case. My simple
How do you
question
know what
is
I brought up in the termination case?
whether or not
I mean-
was this referenced in her complaint? Was it referenced in the investigation?
It
Looking
was.
at, so why don't you
allow it
point?
in though, because
why
you said
don't-
it wasn't relevant. And it is irrelevant because they all chain together. You can't have one without the other.
So can you point out to me in the initial determination where there is a reference to an investigation regarding attendance? Because I don't see it here.
We're not saying attendance. We said the reason she was terminated because she shared a birth date in an ERD complaint, and because they claimed she put misused property, including pornographic material. They needed a serious offense to make it terminable, and that's what they came up. That is what her termination letter said. You would not let us use her termination letter. It's written in black and white right there. When it's fabricated, we can't show you things when it's fabricated months after the fact. we can't produce that to you until we go through the discovery process. That's quite a little bit of a pickle to be in.
Well, I'm going to sustain the objection. I haven't heard you tell me anything that this was part of the claim in terms of sub D and sub E in case number CR 2023000758. I don't see it. My understanding it.
Okay, then I'm going to have Cindy.
Please let me finish. Are you done? Are you going to continue shaking your head and talking, or can I speak?
I'm not shaking my head. I'm rubbing my head.
So my concern is that the only thing I can determine at this hearing and that I can reach a decision on are claims that were made in case number CR 2023000758. I know one of the claims was I was forced to go to a pre-disciplinary meeting because of the fact that they claimed, they being the Department of Corrections, claimed that I provided, for lack of a better word, information to the Equal Rights Division that I shouldn't have, and that was a violation because that was retaliation because I did that. This does not appear to me to relate to that. It appears to me to be entirely separate. So my ruling is the objection is sustained, and we're done. We're not going to get any further into C-53. If there's something further, if you can point me to where this is her claim, I just don't. I'm sorry, I'm struggling to find where it fits within the complaint that was filed. Maybe it probably was part of the termination decision, but we're not here to decide the termination decision. Anything else you want to say on that topic, Ms. Keither?
No, there's no point. So I'd also like to ask you, Ms. Eplet, and this is really getting to be the end of our questioning here. Do you know if state employees can file whistleblower complaints?
I believe they can. I'm sorry, Michelle.
You know,
It's okay.
Attorney Zakar.
You've already answered it. It's okay.
do you know if Cindy Ostrowski ever filed a whistleblower complaint?
Relevance, objection.
What's the relevance?
Well, the relevance is when you have to go outside of the chain of command, when everything that you do with a chain of command is covered up, deleted, fabricated, then sometimes you have to go outside and exhaust another measure of complaint. And the insinuation that Ms. Ostrowski went outside of the chain of command was when she was filing a whistleblower complaint. There you go.
The objection is sustained. Any other questions for this witness?
Yes, did Ms. Ostrowski have a 1507? 15807. That's the question.
For what?
For anything.
I'm aware of 3.
Okay. And what were those 15807s for? The ones that you're aware of, the 3 that you just said you're aware of?
I think the first one was it was an insubordination write-up, and then there was the attendance, and then the PHI.
Okay. And do you know how many forms for 15807, how many accompanying forms need to be with that document?
You mean the complete packet?
Yes, and my understanding is for a 15807 to exist, that there has to be a number of forms that are completed in order to generate that. Like Form A, for example, and Form B, all the way up to Form, what was it, Attorney Zakar H? That all of those are required to be with a 15807. That's just the way the procedure works. Are you aware of that?
I'm going to object as to relevance.
What is the relevant? Well, here's what I'll say. I do see some relevance, perhaps, potentially, as to the 15807 807, that relates to the PHI. And so the objection is overruled. That's really the one I'm interested in, but maybe the general question, the general question probably is applicable to all three categories that all three 15807s. So I would like to know the answer to the question, and let me get back to the question. Was the question, does she know how many documents are attached for a complete one? Is that the question?
Well, I was asking her if Ms. Ostrowski's 15807s had forms A through H attached.
Okay, which one though?
To-
Because she said there were three of them. The only one I'm interested
Well,
in is the PHI one.
Well, then that's the one we'll focus on.
Do you know?
I can only make the assumption that it should have been a full packet, but the only thing I can say, I mean, I don't think in this case, but in other cases, I don't know that the entire packet would be filled out, but I think it is like A through H or A through
Okay.
G or something like that. That's the complete packet. If I'm recalling correctly, but again, it doesn't necessarily always have to be filled out in its entirety.
Well, okay, so what do you mean, what doesn't have to be filled out in its entirety? All the
Well,
forms or?
Yeah, so like my recollection is, so you have the entire packet, but if you never get to the predis, that wouldn't be filled out. Um, you know what I mean? Like, so if you read the investigatory and there's a decision that says we don't believe discipline is appropriate, you could do a letter of expectation, or you could do job training, or you could do, something like that. You wouldn't have a predis. You would still have a summary, but you wouldn't have a predis, and then the preceding pages filled out, because that never happened.
Okay, so do you recall seeing those forms completed with Ms. Ostrowski's PHI investigation?
I can't say that I recall seeing the entire packet and everything that was written, but I can only make the assumption that for the most part, because it went to predis, then it should have been filled out in almost its entirety. And if it wasn't, I wouldn't be able to say why without seeing it.
Okay. But the department should have a record of that, correct? You would think?
Objection
forms.
relevance.
Well, the objection on relevance is overruled. Go ahead, answer the question if you can, if you know.
I would think the packet lives somewhere.
Okay. All right, well, that's our questions. Thank
All
you.
right, Attorney
And-
Zacard, you are entitled, if you have any questions on what we would call redirect. Do you have any limited questions on redirect?
I just have, I think, one question.
Go ahead, please.
Thank you. Ms. Epplett, is an employee discipline investigation the same as a breach incident investigation?
My first response is no, they're separate, because a breach doesn't necessarily, I mean, a breach is a breach, an investigation is an investigation. Whether they collide, but you can have a breach and it doesn't necessarily lead to an investigation, if that makes any sense.
Okay, thank you.
All right, Ms. Epplett, your testimony is complete. Thank you. I know it's been a long day for you. You are free to go. We have a sequestration order in effect. It's kind of moot at this point because you are the last witness other than Ms. Ostrowski. However, regardless, I will instruct you not to speak with anybody else about this case until this proceeding is complete. You can certainly check with Attorney Zacard if you are so inclined. This proceeding should be complete today. So with that, please don't talk with anyone until you confirm one way or another that the case is complete. Again, thank you for your testimony. I know it's been a long day and you are free to go.
Thank you.
Take care. All right, so where we're at now, I believe, is we're going to take up continue the direct examination of Ms. Ostrowski. Attorney Zacard, have you been able to deal with your camera issue?
Oh, gosh, I'm sorry. I didn't even try to fix it. Let me see if it works now. I might have to, oh, there it
Why don't-
goes.
Oh, there we go. All right, so that's great. So
It-
is everyone good to continue directly into Ms. Ostrowski's testimony?
I'm
Yes.
so sorry, but I just need a 2-minute break.
It's okay. I anticipate that's all right. So let's take till 1:57. We will come back. Ms. Keither, do you know if you're going to use exhibits, and if so, how many?
Hold on. Yes, exhibits. We have 9 exhibits.
Okay, and can you tell me, are they all complainants or are perhaps some of them respondents also?
At
Both?
this point, they are all complainants.
Okay, great. All right, we will
Um,
see everyone back in about 4 minutes. We'll just come back at
Okay.
1:57. Thank you.
Thank you.